Okay, thanks for joining us, and good afternoon. This is the panel which looks inside Cayman's hedge fund industry. The title for this panel is that Cayman is the leading jurisdiction for the domicile of hedge funds, and we are to look at the state of the industry and the pros and cons of Cayman for sponsors and investors. And in particular, we're going to be looking at professional directors, conflicts of interest, transparency, regulation, and cost. My name is Matt Mulry. I'm with Dillon Eustace. We're a financial services firm. We're the largest financial services firm in Dublin, in Ireland, and we practice Irish and Cayman Islands law, and I head up the Cayman Islands office for the firm. To my left is Don Seymour. Don is the founder of DMS Offshore Investment Services and serves as Vice President of the Cayman Islands Directors Association. Don is also a member of the Financial Services Council of the Cayman Islands Government, which provides strategic advice to the government on financial services industry in Cayman. And to my far left is John Prout. He is an executive director of the Foundation for Fund Governance in Washington, D.C., and John has previously set up and run trading desks at a number of major international banks. And he's also served on the boards and the investment committees of a number of hedge funds. So thanks to you guys for joining me. And turning to our first subject, professional directors. Now, there's been considerable interest in the role of Cayman hedge fund directors following the financial crisis and the Weavering decision in August 2011. And that interest has led to revised corporate governance codes in most offshore jurisdictions. In order to effectively adopt good corporate governance practices, it's essential that we understand the approaches that are taken to the provision of directorship services directorship services to Cayman hedge funds. And if I could start then, John, by asking you to take us through the different models which you've seen being used for the provision of directorship services.
Sure. Thank you. Actually, these are just talking points for us to sort of have a little debate or discussion on what are the different models. I think just too many to count. So I've picked sort of the three common formats, starting with the individual or personal director, which using a medical analogy, which probably is going to get me into trouble, I call the concierge doctor model, where you basically have an individual that's selected for his judgment, skills, and experience, oftentimes somebody who's retired or in a current position in the financial services industry, may have specific skills such as language speaking, that's relevant to the particular fund, or a derivatives background, or an accounting background, or a legal background. Second point, or second characteristic, has the time and energy to personally prepare, attend, and participate in the board meetings and committee meetings that are required. And third point, or characteristic, likely to remain independent, since the likelihood or since he doesn't have to rely on director fee income for his livelihood. And perhaps more importantly for those directors in the United States, personally liable, personal assets on the line in the case you're found negligent as a director. And probably in most cases familiar with the manager and with the investors. This model has some weak points. First of all, such directors, if they're not resident in the domicile where the fund has been set up, may not be licensed, and certainly is not going to be regulated or necessarily known by the local regulator. It does open up the possibility that the hedge fund manager chooses somebody that's rather accommodating or compliant, as we saw in the case of Weavering. And third, more often than not, probably lacks the experience in AML, KYC, and the compliance and legal and regulatory issues that concern a fund. The second model is more the boutique that we're becoming familiar with, which is a partnership structure basically of, if you keep the analogy, concierge doctors. These individuals are personally liable, but the partnership is licensed or supervised by the regulators in the domicile that they've set up. Cayman in particular has an increasing number. The cons of that is there's obviously limited scale, because these boutiques self-impose on the number of relationships that they establish and the number of appointments they take on. The ability to extend their institutional knowledge is also therefore limited unless they bring in additional partners. And last but not least, the likelihood of this model working is going to be dependent upon the evolution of fund governance continuing. That brings us to the full service professional fiduciary services model, which we're familiar with. And I think Don can speak more to that. We would just make a couple of points that it's been the most popular model for probably two business reasons. One, it's priced for it to be attractive to hedge fund managers who are cost sensitive. And secondly, at least in my personal opinion, towards hedge fund managers that prefer more independence rather than oversight over their activities. The cons is that the jumbo directors, as it's commonly called, has at the very least, the appearance of insufficient bandwidth to devote to fiduciary duties. And there are also some of these professional fiduciaries that double dip by also providing legal and accounting fees through affiliates, which open themselves up to potential conflicts of interest. And last, there is a not terribly well-known phenomena where the employees that are acting as directors are personally liable, and yet, and I've reversed this thing, it's Paget-Brown, not Brown-Paget, as a court case that I understand basically protects the employer from being sued in the case where the employee acting in the director capacity is deemed negligent. And that's sort of a bizarre kind of situation which is not terribly familiar in the U.S. I'll pass this on to Don.
Thanks, Tom. Don, maybe you could just give us your view on the pros and cons outlined there, and maybe tell us how DMS operates.
Sure, and thank you, Matt. I think it's important before I talk about where we are today is to talk about where we've been, because it's very important that you understand the history of this issue, because that has shaped the direction of the growth of the industry in the Cayman Islands. So I'll take you back to 1997 when I was hired by the Cayman Islands government to be the first head of investment services at the Cayman Islands Monetary Authority. Now, they hired me to develop the regulatory framework for hedge funds. And back then, the Cayman Islands didn't appear on the league tables in the hedge fund industry at all. If anything, we might have crept in to number 10 on a league table 1 to 10. So my job was to write all the policies and procedures, hire all the staff, set the general policy direction for the hedge fund sector in the Cayman Islands. And as I did this, and the industry started to become very successful, I saw that in addition to attracting the good funds, we were also attracting some bad funds. So back then, I was responsible for the entire sector, so I was responsible for authorization, supervision, and enforcement of the hedge fund sector. So I had to take enforcement actions against the bad hedge funds that we were finding in the sector. And what I saw at that time was that the common thread throughout all of those enforcement actions was the fact that the funds didn't have good fund governance. And I rationalized back then that governance needed to improve if the hedge fund industry was going to continue to grow, if it was going to continue to be successful in Cayman. We had the best directors in the world. We had the best administrators in the world. We had the best lawyers. We had the best accountants. But what we didn't have was good directors back in the late 90s. So I would go out to the industry, I would give speeches, and I tried to persuade the industry that they needed to improve governance practices, or we were going to suffer some severe issues in terms of continuing to grow the industry. And nobody really listened, because back then, nobody treated governance seriously. So in 2000, I said that I was going to do this myself. And I set up DMS in 2000. We were only one person back then. And DMS grew from there to over 200 people today. We're in 6 offices around the world. And we represent client funds with over 275 billion in assets. So what is behind that success? Why have DMS become so successful? Because a large part of the success of governance in the Cayman Islands has been the success of DMS. As DMS became more successful, more and more people were attracted to the industry. And today, the Cayman Islands has become a magnet for governance professionals all over the world who are attracted to the Cayman Islands to set up governance services. So it's been a great success story. So what has made it different? What I saw from my time as the chief regulator was that if governance was going to be effective, it needed to be a process. There is no single mind of any one director can comprehend or manage the full range of risk in any hedge fund. So you cannot effectively manage risk without a process. So the idea behind DMS was that we would have that process, that it would be a system of checks and balances. And today, I know John's comment about the perception of lack of oversight, but it's to the contrary of that. Every single transaction, every single governance transaction at DMS is reviewed 3 times. So there's a system of checks and balances that really help the funds to better manage risk. So as we see governance evolve, some will say that it is a quantitative calculations. It's X amount of directorships and X amount of board meetings, and that is the governance formula. That has not been our experience, and we have been doing this longer than anyone in the industry. It's now been 13 years. So in our experience, what we find is that the governance failures are usually in those services where there is not a process. Whether you're a single director on your own or you're a single director in a firm, you do need to have an effective system of risk management to avoid governance failures.
Sure.
Yeah, just add a trader and hedge fund manager's perspective, starting actually from 1997, Dom, because that was actually when I first went to the BVI. I couldn't afford Cayman at the time to set up a fund of hedge funds. And I met with Barclays Private Bank, who did fund administration, but realized that they really didn't know how to do an NAV. They could just do subscriptions and redemptions. So I then got Mark Chapman at Deloitte, who was the partner, to do the NAV accounting. And then I thought it'd be good to get his competitor, John Greenwood at KPMG, to be the auditor for our fund of funds. And so we've had a real stellar startup. And we totally forgot the idea of a director until I think it was Barclays that said, by the way, you need a director, at which point we said, why? And then we were told, well, it's a company, and so on and so forth. And I think a lot of people in the hedge fund industry back then really had that same afterthought reaction of, well, we have to have directors on our offshore funds. And you know, fund governance is not just about directors. I would say that 10 years ago, the hot topic when I was speaking at conferences was portfolio transparency. We started in the 80s and 90s with high net worth individuals as the primary investing group in hedge funds. And as institutions started to come in, they wanted to know well, what's in the portfolio? It wasn't good enough to say, trust me, don't worry, I've got the best stocks that I'm going to have, or the best credit derivative, blah, blah, blah. So the demand for transparent portfolio transparency was the first real driver by the institutional investing community. Then in 2008, it became custody. Custody, of course, triggered by Madoff, because all of a sudden those assets that were custodied weren't there. And then in 2009, as people tried to get out of their investments during the 08 crisis, as liquidity dried up, the issuance of side pockets became to the forefront. And that's when the institutional investors focused on directors and saying, well, how did this happen? We wanted our money back, and all of a sudden they've been suspended for a year, or we're only getting 80 cents or 70 cents on the dollar, and the rest of it in this funny paper called the side pocket, and so on and so forth. So we've had a transformation in the industry where we've gone from different stages as far as governance is concerned, and it's all been institutionally driven. And to this day, and my favorite comment is of a New York lawyer who sets up a lot of hedge funds. He said the problem is that hedge fund managers still refer to their business as my fund. And it's not their fund. It's the investor's fund. And when you're talking about very strong-willed hedge fund managers, it makes the job of a director very tough. And you know, that's why we have the different models. That's why we have the different approaches. You have people who leave the Goldmans and Morgan Stanleys of the world and basically say, I'm free of my bosses, I'm an entrepreneur, and I don't want to have to account to anybody except my investors. They're either going to like it or not, and they'll walk if they don't. And they don't quite understand that to receive institutional money, particularly from tax exempts, that privilege of managing or investing money comes with a responsibility. And whether it's going to be driven by independent directors, or whether it's going to be driven by the investors themselves, or the hedge fund managers wake up, or worse, the regulators step in, it will occur over time.
Thanks, John. One of the issues that we'll consider on this panel is also conflicts of interest, and a classic conflict arises with one of the common types of directorship services firm that's common in Cayman, and that's where a law firm sets up its own fiduciary services company, which I think is the HMO model that John refers to in his slides. The structure of these companies is that the law firm partners, or the most influential of those law firm partners, own the company that's providing directorship services, and commonly there's a direct referral made by the law firm who acts for the investment manager at the establishment of the fund, refers the directors to the fund directly, and so you end up with a fund that's been established. The law firm is now acting for the fund, having moved on from having the manager as its client. And the directors who act on the board of the fund have their salaries, their bonuses, their employment heavily influenced by that law firm. Whilst there are other services or service providers in Cayman who provide mixed services, directors and other fund services, I think that the law firm and the director's business is perhaps one that has become talked about most in recent times. And there's been a move, largely influenced by investors, away from those types of directors being used on funds and towards split boards, where you'd have a director provided by one fiduciary services company and a second director provided by another, in order to reduce that perceived conflict. Maybe, Don, could I ask you how you see those conflicts of interests affecting the industry?
Sure, and thanks again, Matt, for that question. As it relates to legal counsel serving as directors, certainly this can lead to several conflicts of interest. I'll start first. The law firms will say, well, you have two models. You have essentially the model that exists in Ireland, and then you have the model that maybe exists in Cayman and other places. Although in Cayman as well, you do find on certain occasions a bit of the Irish model. In the Irish model, you essentially have the lawyers themselves, which will serve as directors on hedge funds. And that is problematic in the sense that, well, you certainly can't give an act on the same advice. That would present a conflict of interest. Also, as it relates to capacity, certainly a lawyer, a busy hedge fund lawyer is probably charging 2,000 hours a year or more serving clients. So one struggles to understand how a lawyer can present a timesheet with those hours and also then say that they have devoted significant time and attention to discharging their duties as a director. So inherently, I see some conflicts there. As it relates to the way that the practice is followed in the Cayman Islands, where the law firms will set up separate companies and employ directors, which they offer to the funds that they advise, I see that conflicts of interest can develop with that model, in the sense that certainly the employees of the fiduciary arm, is acting on the advice of the law firm, and there has been at least one high-profile case in which the court raised significant concern about whether or not the directors in that case, and this is the Cayman Islands court, by the way. So the court raised significant concern about whether or not the directors in that case were acting in the best interest of the fund, which they are obliged to do under the law, or they were acting in the best interest of the law firm. Because in that case, the law firm had a significant business relationship with the sponsor of those hedge funds. And there was considerable evidence, even though the court did not specifically address that issue, there was specific, significant evidence that the court found. And to use the Chief Justice's term, he said he was led to an irresistible impression that the directors had acted in what was the best interest of the law firm. So those conflicts can be quite significant, and in that case can be quite devastating to investors. And investors today are more focused on it. It's likely to move into sharper focus as well once the SEC starts to focus on this issue. Undoubtedly, you know by now that most managers are regulated by the SEC, and the SEC last October, they started their, what they call their presence exams, which means that they're making a sweep throughout the industry, and they're going to be examining the practices of all the newly registered hedge fund managers. Now, the SEC has what is called its exempted rules, and for you to rely on them, you have to be independent. And the SEC has a director, and the SEC has a very strict definition of what independence is. And the way that the industry is practiced in Cayman, it's unlikely that it would meet that level of independence, which means if that a director of a law firm affiliate would not likely be able to apply on to rely on the exempted rules, if the SEC takes issue with that. So it's an issue. We're just at the law firm that I mentioned in the last case, where the judge was led to the irresistible impression that the directors did not do the right thing. That law firm has exited this practice, and this issue is still evolving, and we'll see how things go in the next year or so.
Thanks, Tom.
Yeah, I would add it's the appearance of bias and not just the presence of bias that I think is the troubling issue when you do have this kind of conflict of interest with legal firms providing directorships. But if we take the larger picture here, it's hard for me to imagine. There's only one way that I would feel comfortable as an investor with a board that had the ability to keep in check some of these inherent conflicts of interest that you're going to have by definition, and that is through the split board. And this is the, not that I like taking the United States as an example, because the GP-LP structure, we have no governance for hedge funds in this country. But since I'm in Miami on U.S. soil, if I can cite the U.S. mutual fund industry, we have a majority of the mutual fund boards are independent directors. They do have their own independent legal counsel on retainer, separate from that of the fund manager. So there are aspects that control the conflict of interest. I think we can see some improvement that needs to be done in the hedge fund industry. There are, what we've done by data mining the SEC and other websites, we combed through 13,000 documents, and we have 10,900 directorships that have been identified around the world, held by 1,900 individuals on roughly 7,000 funds. 5,500 of the 10,900 directorship positions we've identified are held by the 223 Cayman residents that we have identified from SEC, principally Form D and ADV Part 2 filings. This universe that you're seeing here, that mass blob in the middle, are where the majority of those 10,900 directorship positions are. And you'll notice the reason why I'm putting the, you see the outer data points, those are directorships in different countries, but they're not connected to each other. They're not split boards. If we go and look at split board relationships, which is what this graph shows you, and the size of the dots, the larger dots are where the fiduciary directors have the more positions that one individual has, the bigger the circle. So you'll see that, and let's call them jumbo directors. You'll see in the BVI on the left in crimson color, that's a jumbo director, a fiduciary in the BVI, and then there's a few in quite a number in Cayman, and then there's an orange one in Bermuda. But the interrelationships that they have, who are they sitting on the board of? So you'll see Jersey and Luxembourg are providing directors on a particular number of funds. The thicker the lines, the more funds in which they're having split board relationships. So what we'd like to see is more thicker lines between the different jurisdictions to give a split board where you have directors from different jurisdictions with different perspectives and therefore improved level of governance.
I mean, other than this, I've seen this information before, and I mean, there are tremendous gaps in it. I can think of many service providers in Cayman that would either be, would probably be not just Cayman, but actually Ireland and Luxembourg as well, which would be disappointed to see that they're not on the list. So it's really hard for me to speak to that information. I think it really needs to be scrubbed and maybe and maybe a redo is necessary. But other than that, when you think about split boards, I think about, well, what are you seeking to achieve? I mean, it's a fallacy to say that all directors think alike. When you build a board, you try to build a board that has a mix of talents and experiences. That's key. This idea of splitting, it's already split. Directors' duties are joint and several, and any director will tell you that. So this idea that a director is just going to go along with another director, I think it's a silly director that actually does that. When you look at the way that the hedge fund business actually works and you look at what people want, from their boards. The boards today are more consultative. They want people with a mix of talents that can help them better run the fund. So you want people on there with regulatory experience, accounting experience, compliance, everything. You want a range of talents on your board, and you should pick your board like you do any other service provider. You pick them based on their talent, based on their competence, based on their experience, based on their track record, and also, and this is very important, on an alignment of interests. Now, when I say that, the first tendency is, well, what do you mean an alignment of interests? And I note John's earlier comments about the manager referring to it as his fund, And the idea is that all of the service providers need to be aligned. They have to all be working towards what's in the best interest of that fund. So not just an alignment with the manager, but also an alignment with the administrator, with the auditor. Everyone needs to work. It's a fund control structure, and you can't have dysfunction within the fund control structure. If you have dysfunction, it will mean losses for the investors. So you do have to have directors who truly understand that, and directors who are not antagonistic to that. If you truly believe that you can put in some idea of a Superman director who is going to mitigate all your risks of investing in a fund, don't invest in that fund. If you truly have concerns about the integrity of that manager or any other service provider, then no director is going to save you. No service provider is going to save you. You have generally, in the 13 years that I've been doing this, I will tell you that most managers want to do the right thing. Most managers act in the best interest of their investors. The instances of fraud and bad dealings are actually very, very small. Cases like wavering are very rare. For the most part, you invest in a Cayman Islands fund, that fund is going to be run by people who have integrity. So it really depends on what your premise is. If your premise is that most of the industry is bad and directors are going to mitigate that risk for you, then don't invest to begin with.
I think I would beg to differ slightly in the sense that we have a model called trust, which I agree with Don, but verify. And there are no Superman directors, we agree with that, which is why split boards are an important element of fund governance in our opinion. And in all defense to our database, I would say that every single piece of information we have is backed up by a filing with a regulatory authority. Most of them are SEC, and they're all available on our website.
Okay, thanks, Tom. So there's been a call for greater transparency in all financial services industries, and it's been a common call amongst politicians, regulators, and investors. Now, Cayman imposes an overarching requirement to disclose all necessary information to enable an informed investment decision, and the regulator doesn't prescribe specific transparency requirements. And as such, Cayman has evolved a transparency which has been driven by investor demand rather than by regulatory interference. And I mean, John, you can see, has put together a large database of information on investment funds. Perhaps, John, you can give us an idea of what the key areas that investors should be considering when they're looking at transparency requirements or additional transparency requirements from funds.
Well, let's first start as to why is this important? Why should institutional investors have more information? And this gives you just an idea of as Don knows very well, better than all of us, how important Cayman is in the hedge fund world for U.S. tax-exempt investors. If just based on our limited, very limited resources, we were able to download from the Department of Labor and the U.S. Treasury, Form 990s, filings that are required of U.S. tax-exempt institutions, by which I mean public and private pension funds, university endowments, labor unions, city, state, municipalities, and so forth. And not all of those filings, in fact, only a small number of those filings actually detail their hedge fund investments. But as you can see, we were able to take 181 institutions, 180 if you eliminate the one fund of funds in the upper right-hand corner, and identify $145 billion worth of hedge fund investments. And this is actually December 2010 data, so it's obviously larger than it is now. So if you take a look at some of the names, Pennsylvania Retirement, Carolina, we have very substantial institutional investors that are tax exempt, that are investing in hedge funds, and there's a good portion of what they invest, as you can see in the lower side, Cayman benefits from many, many tens of billions of dollars of U.S. tax exempt money. Overall, we have 6,000 funds and have identified almost $4 trillion of investor assets that have been placed in over 6,000 hedge funds. So that's the reason why we want to know what the importance of the transparency. I just go back. Now, Cayman Monetary Authority is proposing opening up its database. Our attitude is that whether they do this or not, somebody in the public or private sector will eventually get it, and the SEC already provides that in, unfortunately, not a very data-friendly form, so it took us well over a year and a half to get these 10,000 directorship appointments identified, but they are all signed by the directors and their companies noted. So this is not going to be something that I think is a big issue. It'll just come out as it is already doing.
Thanks, John. And Dr.
Yes.
Yeah, sure.
Just quickly on the transparency issue, as Matt said in his comment that Cayman is a disclosure-oriented regime. It's also a regime for sophisticated investors. Any investor can get any information that they need to successfully invest in a fund. I truly don't understand the obsession with numbers. If you want my number, I'll give it to you right now. It's 158. I also will tell you the amount of meetings that I do every year. I do on average 2 meetings every day. I probably do between 400 and 500 meetings a year. This is all that we do. We are full-time directors. We're not part-time or retired guys. We're full-time directors working in a professional firm with professional people surrounded by sophisticated technology, and we have an unbelievable process that manages risk better than anyone else in the world, and that's why we have become successful. It's just untenable for anyone to suggest that an investor can go to a sponsor and be able to negotiate any form of side letter that they want, but not be able to get information from a director. I mean, it's purely a solution in search of a problem. So the whole idea behind transparency, in my view, it's not asking the right questions. I do believe that fund governance should be regulated. That's why I actually set out on this mission over 13 years ago to do something about improving fund governance. But fund governance should be regulated the same that you would regulate any other service provider to a fund. And there are fundamental tenets of regulation that as fundamental as accounting assets and liabilities and equity. You have authorization, you have supervision, and you have enforcement. So I think that we in the Cayman Islands should regulate the area in a proper way. There should be a regulation around authorization, that only the right people, with the necessary qualifications and so on are authorized. Then you have supervision, which means that it's quite clear what the expectations are of those people. And then in the end, you have enforcement, which is if those people don't act in the manner that they should act, then you disqualify them or you take some other type of sanction against them. So as we move forward, these transparency and databases and so on, they don't address the real issue. And the real issue is this. This is the last unregulated sector in the hedge fund control structure. Let me say again, every other service provider to a fund is regulated except the directors. It's just a gap, and the gap needs to be closed, and you should regulate them the same way you would an administrator, an auditor, a prime broker, authorization, supervision, and enforcement.
Thanks, Don. And we're a bit tight on time for this panel. So certain members of the panel need to catch flights this evening. So what I'm going to do is just very quickly deal with regulation and then invite any questions that you might have for the panel. And many of you will know that Seymour are or have been in the process of consulting on a corporate governance code. And the key elements of that code are disqualification provisions for directors, limits on the number of directorships held, and a public register of directors. And Don, maybe if I can invite you to give us just very briefly your view on those proposals, and if you're able to share your thoughts on how the consultation process is being conducted.
Sure. Well, Matt, I may have said some of this before, may have got ahead of myself. We believe, we mean in DMS, DMS believes that that fund governance should be regulated. It should be regulated in a proper form, which means a regime that allows for authorization, supervision, and enforcement of hedge fund directors. We think that's very important for the future growth of the industry. As it relates to the Seymour consultation process, we don't feel that it goes far enough and it addresses the right questions. I think that it would be important for the regulator to look back at the experiences in the Cayman Islands sector and develop a regulatory solution to address those concerns. Specifically, the regulator should take note of what has happened in the Weaverin case, for instance, and other cases in Cayman, and take the lessons from there and apply it, and use those lessons to develop regulatory solutions.
Thanks, Don. And John, maybe you could give us your views on the code.
Yeah, the only thing I would add is I think from an outsider's perspective, it was disappointing that the Cayman Island Directors Association was unable to come up with its own response to the Cayman Monetary Authority's proposals. And that's sort of, to me, symptomatic of the situation that we have, that there is a broad mix of opinions, and hence the reason and importance of having the transparency, so not only people on the island can express their thoughts, but investors and others outside of the island, given the importance that Cayman holds as virtually 70% of the hedge fund industry.
Thanks, Tom. And then, just being conscious of time, maybe I could just ask if anyone's got any questions to our panel on any of the issues that we've discussed. Sure. Do you mean the minimum around the directorship services? What's the current regulation?
Right. That, in a sense, is the essence of the problem, because right now you have over 10,000 individuals who serve on Cayman Islands funds all over the world. there are about 250 of those individuals who are based in the Cayman Islands. So the issue that Seymour would have would be, how do you effectively regulate, some 9,000 plus directors who sit outside of the jurisdiction? Now, it's also important to know that there are no restrictions whatsoever on who can serve as a director to a Cayman Islands fund, and there are no minimum qualifications for that. That in itself is not an issue to me personally, but I certainly do take issue with the fact that if someone doesn't do what they are supposed to do, that the regulator won't disqualify that individual. And there's certainly, if you look back at the Weavering case, for instance, those directors are still fit and proper to serve on another Cayman Islands fund. And we think that is an untenable situation, and that needs to be rectified, and that the regulator should focus on a regime that will address those issues.
And that actually proves, I think, our foundation's point that they are able, the Weavering directors can serve on another fund, and I can tell you that directors that have been sanctioned in the Southern District Court of New York are serving on hundreds of funds as we speak. So we don't have a disqualification program, and until we do, we believe that the transparency issue is important for investors.
Yes, Simon.
Just on that, I may be confused, but I thought Seymour substitute directors in the lead. So in the Weavering example, and in the example you joined the Southern District, why that hasn't happened? But it isn't right to say that they just there is a mechanism for substitute.
Simon, we don't have a good answer for you about why it hasn't happened. I mean, we strongly believe that it should happen, and we think that all of the discussion around, transparency and database is fine. I mean, even if you want to do that too, but address the real issues. We need proper regulation. We need authorization, supervision, and enforcement. And I mean, as well as I, how the mutual funds law is structured and how it regulates other service providers to the fund. And we're advocating for that, for directors as well.
Okay, are there any other questions? Yeah.
Don't most of these directors sign indemnification agreements that hold them harmless in the event of anything going wrong at the fund? Cross indemnifications by lawyers and accountants and directors.
There's two.
So what the hell difference do you think?
There's two approaches. One is you would rely on the articles where there would be an indemnification provision from the fund to the directors, but there would be an exclusion for any negligence, fraud or willful default commonly included within those indemnifications. So if a director was at fault, you wouldn't expect those indemnification provisions to bite. You would look at the Articles of Association.
But I'm talking about the facts or whatever happened to find that stuff.
I'd imagine it would be for litigation. Is that right, Simon?
Yeah. And it may be important for you to know that the negligence standard, and I mean, we have a lot of lawyers here who can clarify, and I'm not one. But the negligence, there's no concept of gross negligence in the Cayman Islands. So it's not as easy as it may sound. So negligence in Cayman would be essentially what you may know as gross negligence in the US or in Delaware. Right? So it means that the director would have done something really bad, and he would not be indemnified. He would not be indemnified for that if he's done something really bad. I think I have that right. And a lawyer can clarify. Always get a bit iffy when I give legal advice.
We should wind up there. Well, thanks everyone for listening to the panel, and sorry we have to cut it slightly short. If you had wanted us to go on, but thank you.